All rise.
Thaci, come.
The Kosovo Specialist Chambers is now in session. Please be seated.
Good afternoon, everyone, in and outside the courtroom. Mr. Court Officer, can you please call the case?
Good afternoon, Your Honours. This is case number KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Vaseli, Rajab Salemi, and Jakub Krasniqi.
Thank you, Mr. Court Officer. Now I kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Good afternoon, Your Honour, and to everyone joining. For the Specialist Prosecutor's Office today are Alan Tiger, Senior Prosecutor, Vord Ferdinandus, Head of Investigations, Marlene Yaya Haga, Legal and Disclosure Officer, and I am Claire Lawson, Head of the Legal Office. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense. May counsel introduce their teams, starting with, I don't know if it's Mr. Prosper or if it's... then please proceed.
The interpreters cannot hear the defense.
The interpreters just mentioned that they cannot hear you, so there might be a problem with the microphone, but I see that your microphone is on, so it shouldn't be a problem. So let's see how this can be fixed. It might be because this microphone does not work.
Can you hear me now?
Now I can hear you perfectly.
Okay.
And just for the transcription, it's not Mr. Kihui. So for the transcript, this is not the right name.
Okay. Yeah.
Sorry for these technical issues.
No problem, Your Honor. My name is Luka Mišetić on behalf of Mr. Thaci. With me are co-counsel Sophie Menegon and our legal associate Bonnie Johnson. And remotely with us are co-counsel Mr. Pierre Prosper and Mr. Dostid Palaska. Thank you, Your Honor.
Thank you very much, Mr. Mišetić. Mr. Emerson, please.
Good afternoon, Your Honour, and to everyone in and outside the courtroom. This is Ben Emerson appearing on behalf of Mr. Vasili, together with co-counsel Mr. Nicholas Kaufman.
Thank you, Mr. Emerson. Now I turn to Mr. Young, please.
Yes, good afternoon, Your Honour, and to everyone. For Mr. Rajab Salemi, David Young. Thank you.
Thank you, Mr. Young. And now I turn to Ms. Alagendra, please.
Good afternoon, Your Honour. Venkateshwari Alagendra for Mr. Jakub Krasniqi, appearing together with co-counsel Mr. Aidan Ellis and Mr. Mentor Bachiri.
Thank you, Ms. Alagendra. For the record, I note that Mr. Thaci, Mr. Vaseli, Mr. Salemi, and Mr. Krasniqi are not physically present in the courtroom, but attend this hearing via video conference. Now I turn to the counsels for victims. Mr. Laws, please.
Good afternoon, Your Honour, and to everyone. Simon Laws, counsel for the victims in this case.
Thank you, Mr. Laws. And now I turn to the registry. Mr. Registrar.
Thank you, Your Honour. For the registry, Stefan Wolfart, Deputy Registrar, and I am here with Dr. Frida Madonna, Registrar. Thank you.
Thank you very much. Before we proceed with our agenda today, I remind the parties that should anyone attending the status conference via video conference experience any technical difficulty, please inform the court officer and myself immediately by waving your hand. Let me now move to the recent procedural history of the case. On 12 July 2021, I scheduled this 6th status conference. I asked the parties to provide written submissions if they so wished. On 16 July, the SPO, the defense for Mr. Thaci, the defense for Mr. Krasniqi, Victims' Counsel, and the registrar submitted their written observations. I thank these parties and participants for their written submissions. Based on those submissions, I have modified the agenda slightly to include all the following topics. Update on preliminary motions. Disclosure. Disclosure of material obtained during search and seizures. Case-specific categorization in legal workflow and other matters related to legal workflow and the Rule 86.3b outline. The defense request for preliminary witness list. Translation. The status of SPO investigations. The status of defense investigations. The points of agreement on matters of law and fact. Detention. The date for the 7th status conference, and any other matters they wished to raise. The purpose of our hearing today is to review the status of the case and to discuss the topics I just listed. I will invite the parties, as usual, to present their views in a concise fashion about each item in that order. I remind the parties, as usual, to give prior notice should any submission require the disclosure of confidential information, so we can go into private or closed session. First, I would like to give an update to the parties on preliminary motions decisions. I will issue 2 decisions tomorrow. First, a decision on motions challenging the jurisdiction of the specialist chambers pursuant to Rule 97(1)(a). And second, a decision on motions alleging defects in the form of the indictment pursuant to Rule 97(1)(b). Each of these decisions addresses several motions. I also inform the parties that any deadlines for request to leave to appeal will be extended until after the recess, and this will be done in the decision. I also inform the parties that I will issue a 3rd decision on constitutional challenges in August after the recess. Let us now continue with the first topic that was listed in the scheduling order, which is disclosure. I would first like to hear from the Specialist Prosecutor's Office on the progress made in the disclosure of evidentiary material. In particular, what progress has been made in the disclosure of the Rule 1021b material by the SPO by the deadline of 23 July 2021. In line of this approaching deadline, how much of such materials remain to be disclosed? Does the SPO intend to submit further requests for protective measures for the additional Rule 1021b material? In the affirmative, what is a realistic timeline for the SPO to meet its Rule 1021b disclosure obligations? Then, whether the SPO is on track to provide the defense with a detailed notice of evidence falling under Rule 102.3 by Friday, 30 July 2021. Whether there remain exculpatory evidence in the SPO's custody, control, or actual knowledge that must be disclosed to the defense pursuant to Rule 103, and whether any request for protective measures for such material is imminent. And finally, whether the parties are facing or foresee any difficulties related to the disclosure process with respect to Rule 107 material and whether any application pursuant to this rule is imminent. In particular, in light of the SPO submission on 16 July, I would also like to know the number of variation requests the SPO intends to file and when, a reasonable timeline for submission on pending Rule 107 requests, and finally, the approximate number of expert reports needing to be finalized, as mentioned in the SPO's submissions. These are a lot of topics. I will give the floor to the SPO, and this will be followed by the defense. Madam Prosecutor.
Thank you, Your Honour. As indicated in our written submissions, the SPO does remain substantially on track with respect to Rule 102(1)(b) disclosure. Since the last status conference, 10 further packages of Rule 102(1)(b) materials have been disclosed. Those are disclosure packages 37, 38, 40, 41, 42, 43, 44, 46, 48, and 49. In addition, 2 further protective measures requests were filed on the 4th of June and the 8th of July, respectively. There are a number of further Rule 102(1)(b) packages currently in final processing, which will be released this week. The majority of these remaining packages relate to certain outstanding prior statements and associated exhibits. So those items which were mentioned in the Thaci defence filing will indeed be disclosed this week, subject to certain protective measures issues, which I will address in a moment. With the release of the remaining scheduled packages, the SPO will have largely disclosed Rule 102(1)(b) material, subject to the limited number of discrete exceptions outlined in our written submissions and which Your Honour just mentioned and requested certain further details on. As noted in our written submissions, there was one further anticipated protective measures request that we had anticipated submitting, and this will be filed shortly. By that I mean probably tomorrow. That filing relates primarily to associated exhibits of witnesses for whom protective measures have already been requested or granted. In addition to that, we have taken note of Your Honour's decision on the 7th protective measures request as notified this morning, and in light of that ruling, the SPO seeks authorisation to make a further request for the application of non-standard redactions to prior statements and associated exhibits of witnesses for whom protective measures have already been requested or authorised. The review of those materials has been completed, and the proposed redactions in question are ready. There was a very significant volume of associated exhibits in this case. It's in the range of 2,300 items in total. And although obviously not all of those items require redaction, as a result of the volume, review of certain of those items was only recently completed. The SPO was consequently not in a position to bring an application in respect of such materials before now. While the materials themselves are ready, some time will be needed to prepare the application to the court. As such, including in light of existing ongoing case-related deadlines and the upcoming judicial recess, which we will already be working through to meet those existing deadlines, the SPO requests an extension until the 27th of August to make this further application. Currently, the main potential challenge we have with regard to completing this week's disclosures are technical ones. We are experiencing fairly significant difficulties with the release of material in legal workflow. One example was provided in our filing last week. However, since then, other issues have arisen. Since Monday evening, after packages have been released, there's been a substantial delay before the disclosure actually goes through and the parties in chamber are notified of the package. In at least one instance, a released package disappeared from the sequence of disclosures. And on top of that, shortly after 7 p.m. yesterday evening, we lost access to legal workflow. Your Honour, and indeed the parties may have seen the IT service announcement this morning indicating the need to restart the legal workflow server. And full service was restored at 10:38 this morning. Currently, or at least as of shortly before this hearing, the missing disclosure package remains missing. We're hoping that that can soon be resolved so that we can continue with the other scheduled disclosures. And we are reporting each of these issues as soon as they arise, and we're very grateful to the registry for their continuing availability and the prompt manner in which they are assisting with these issues. However, it is obviously a challenging circumstance in the context of this week's disclosure. In relation to Rule 102.3, the SPO is also substantially on track to provide the defence with a Rule 102.3 notice by the 30th of July. The Rule 102.3 notice will indicate remaining materials in the SPO's possession, which are of potential relevance to the case and which have not already been disclosed pursuant to either Rules 102.1 or 103 prior to that date. The SPO will be making a short request to the Chamber in connection with that list, in particular relating to items for which clearances are not yet available. Since, turning to Rule 103 material, since the last status conference, 4 packages of potentially exculpatory items falling under Rule 103 have been disclosed. That includes, in Disclosure Package 45, a package containing potentially exculpatory items identified amongst the seized materials, which was a matter mentioned by the Krasniqi defence in their filings, so that disclosure has now already taken place. Further review of material remains ongoing, and the SPO will continue to promptly disclose any such material. No protective measures request is currently imminent. With respect to Rule 107, the SPO continues to work very vigorously to conclude discussions with relevant organisations in relation to clearances or, as relevant, potential counterbalancing measures. As Your Honour is aware, we have begun making certain so far very discreet requests to the court in respect of such material, and as I just mentioned, we do anticipate making a further request in connection with the Rule 102.3 notice. On the specific questions that Your Honour raised in relation to the pending items, which is the number of variation requests and when they will be made, all of those variation requests have already been made to relevant institutions and panels. Certain of them, as indicated in the, as you'll have seen from the annex to the filing, it is a relatively discrete number of matters. And for certain of them, the variation requests have actually already been granted. In fact, for quite a number of them, they have already been granted, but we have not yet actually received the materials. For the other pending requests, we can't really give an, it's somewhat outside of our control when those will be ruled upon or we'll have a decision. There's a degree of ongoing litigation in relation to a couple of them. But as we indicated in the filing, these are relatively discrete matters, and where possible, we're actually already providing disclosure of similar or redacted versions of the material in question by the deadline this week. In relation to clearances, again, that is a very limited volume of material. It relates to approximately 5 international witnesses for whom clearances have not yet been received. As of making the filing last Friday, the number was actually 6, but we had anticipated receiving a clearance this week. We did receive the clearance, but we didn't receive the signed statement in a legible format. So the number of approximately 5 remains accurate at this point. In addition, there are a relatively small number of documentary items, and by relatively small, I genuinely mean relatively small. I believe it's less than 50. In terms of the timing for them, again, it's somewhat outside of our control to give you a specific timeline on that, but they are coming in on a constant basis. We're pursuing it extremely vigorously, and some of them continue to come in as we speak. On expert reports, the number of experts in question is 3. And it relates to forensic material, as indicated in our filing. In addition, the actual underlying material on which those reports will be based is being disclosed by the deadline this week. Thank you very much.
Thank you, Madam Prosecutor. Let me now turn to the defense, starting with Mr. Micetic.
Thank you, Your Honor. We acknowledge the SPO's commitment to disclose the 1021B material by Friday's deadline, and note that we have received recently, very recently, packages of hundreds, I believe, documents, including in the hours leading up to this status conference, so we have not had a chance to review those materials yet, but we, of course, will do so. With respect to the materials that are going to be subject to protective measures applications, we note that there was a 4 June deadline that Your Honor set for seeking protective measures for witnesses. Some of these applications, including the most recent filing, are for, I believe, witnesses that have not been previously disclosed and therefore are past the deadline that you set. We understand from counsel today that the materials that will now be the subject of the next application will not involve any new witnesses, but rather will be materials related to existing witnesses who've already been disclosed, and we note that. But we do express our concern about any additional witnesses that would be disclosed or for whom protective measures would be sought beyond the 4 June deadline. Concerning the expert reports, we do wish to note our surprise that expert reports are still being prepared at this stage of the proceeding. Your Honor will recall that in November, the SPO indicated that there would be no reason why trial could not start in this month, in fact. We now have been advised that there are 3 expert reports that are still being prepared and will not be prepared in time for the disclosure deadline. We would ask Your Honor to set a firm deadline for any expert reports that the SPO intends to use in the case well before the submission of the prosecution's pretrial brief, so that the defense is fully aware of all of the evidence that will be submitted or will be presented in the SPO's case. We take note again of the fact that some of this material, now the SPO will seek to disclose its full documents by the end of August. Just for the record, we note that this was supposed to be disclosed at the end of May. You then set a new deadline for this Friday, and now we are going to wait another month, I guess, before we see all of the evidence. We take note of that, and then this will be relevant to our submissions later on preparation for trial and defense investigations, et cetera, but I will wait until we get to those points to address you on those points. Thank you, Your Honor.
Thank you, Mr. Micetic. Mr. Emerson, please.
I'd like to allow Mr. Kaufman, if I may, to address the issues of disclosure.
Mr. Kaufman, please.
Yes, thank you, Mr. Emerson. Thank you, Your Honor. As stipulated in Rule 96.1, the purpose of a status conference is to ensure that the preparations for trial are being conducted in a diligent and timely fashion. Now, I ask how the SPO can be seen to be acting diligently if since the 21st of June, it has given us access to 15 of the 35 disclosure packages released to date. This is not diligence. It's a frenzied, panic-stricken, last-minute dumping of materials. It's frankly quite a shameful state of affairs that 43% of the disclosure packages, which we now have for trial, have been disclosed in the last month. Now, Mrs. Lawson very assiduously, almost with pride today, mentioned how many Rule 102.1b packages were released since the last status conference. What she doesn't mention is that the first of these packages was only disclosed on the 30th of June, package number 37. In other words, out of sight, out of mind. If there's no pretrial judge handling a monthly status conference, as we requested, then nothing of substance is disclosed. Now, as for timeliness, it has not escaped our attention that the language employed by the SPO in filing 398, submitted in advance of this hearing, is guarded and carefully calculated to leave the door open for further deadline postponement requests. And I quote, "The SPO is substantially on track with respect to Rule 102.1b disclosure." This is a mantra which we've heard repeat itself today, and it's repeated in the SPO's pre-status conference submissions. In my submission, it's a more refined form of the same fuzziness which has characterized the SPO's approach to its disclosure obligations throughout. A far shout, I may add, from the cavalier attitude displayed by the prosecutor's representative at the status conference on 17 December 2020, page 199 of the transcripts. He assured us then of a pretrial brief in early July and a trial date in September. Your Honor, a judicially ordained deadline is designed to set up a cutoff point and is imposed in order to maintain the fairness of the proceedings, particularly in light of the continued detention of the accused. A disclosure deadline is not a recommendation or a goalpost to be shifted at the will of the prosecution, or worse still, to be ignored. Let me cite just one example which has arisen recently, which we hope that the SPO will be able to clarify by way of response today, namely the 8th request for protective measures filed on the 8th of July 2021, and which seems to have been submitted in flagrant contravention of the schedule set out in categorization decision of the 12th of March 2021. That's filing 218 in the case record, whereby the last request for protective measures should have been filed on the 4th of June. So we ask Your Honor to make it clear to the prosecution that if such deadlines, which have already been extended, are not met, then the currently undisclosed evidence will not be received, or alternatively, that Mr. Vasili will be granted interim release. Now, I'll just move, if I may, to the discrete matters detailed by the SPO at paragraph 4 of filing 398. Firstly, the pending variation requests. Here, it's not quite clear to us what exactly is covered by this category. From whom, for example, is the SPO asking authorization for a variation of confidentiality? How many of these requests have been made? When were they made? The opacity of the request prevents any reasonable defense input. Secondly, the pending clearance requests. Now, I'm not going to repeat the submission that I made at the last status conference regarding the obscure manner in which Rule 107 materials have been handled. Suffice it to say that Your Honor was seized of a formal request for metadata which would have allowed us to place a check on the prosecution's disclosure activities for this notoriously problematic category of evidence. No ruling has been rendered since this request was made, and the matter seems to have disappeared into the atmosphere like smoke on a windy day. All we know is that the SPO is handling the matter, as Ms. Lawson said, very vigorously. We feel it most appropriate once again to ask that Your Honour order the prosecution to clarify the number of items that it has in its possession pursuant to Rule 107, when these items were received, number of information providers concerned. We also ask Your Honour to demand clarification as to what proportion of these items the SPO has sought to be relieved of disclosure obligations under Rule 102.3 and Rule 103, and what has been done to proffer in lieu thereof counterbalancing measures. This request is now more acute, especially since the SPO, as it appears, will not even meet its deadline for the disclosure of 5 international witnesses falling under Rule 107. If we were to play by the book, Your Honour, these witnesses would not be allowed to testify, not least because the prosecution request for a postponement of the deadline is completely laconic and totally devoid of any explanation as to the nature of the problems encountered in gaining the necessary clearances. Thirdly, regarding expert reports, there is absolutely no justification for disclosure beyond the 23rd of July 2021. Expert reports are specifically referred to in Rule 102.1b and have the same status as witness statements. There is no legal entitlement for disclosing witness statements at a later date, nor expert reports. And the justification provided, namely that some of these expert reports will deal with forensic issues, is not persuasive. The availability of the experts, with all due respect, would not have been a problem if the SPO had managed its resources appropriately. Thank you, Your Honour.
Thank you, Mr. Kaufman. I'll give the floor to the SPO after the other defense team to respond to what has been just expressed by Mr. Kaufman. Let me now turn to Mr. Young, please.
Your Honour, thank you. On behalf of Mr. Salimi, we support very much the concerns which have just been raised by counsel for Mr. Thaci and counsel for Mr. Vaselli. So they won't improve by repetition. I just want to make 2 general comments in relation to disclosure. Firstly, it's difficult for the defence with respect to understand the full scope of disclosure, given the effective piecemeal nature of it, given the fact that there are 6 extensive protective measures affecting, we estimate, around a half of the total number of witnesses, and given the continuing nature of the extensive redactions to the indictment. So, secondly, we would plan to undertake a full stock take, as it were, in August, in the light of the supposed completion of the Rule 102.1b disclosure and the Rule 102.3 list, in order to attempt to provide a comprehensive list of the issues and gaps that we see then in terms of disclosure. Thank you.
Thank you, Mr. Young. Mr. Lagendra, please.
Your Honour, could I defer to Mr. Ellis to address issues of disclosure?
Absolutely. Mr. Ellis, please.
Thank you, Your Honour. Your Honour, we've set out a number of our points in writing before today. In relation to the matters that have arisen from the SPO submissions this morning, there are 2 points in particular that we would wish to highlight. First of all, in relation to the experts issue, Your Honour, the starting point, as I think Mr. Kaufman said, must be that both Rules 149 and Rule 102.1b make it clear that expert reports should be disclosed by the final date for the Rule 102.1b disclosure, which is, of course, in 2 days' time. So what the SPO is effectively seeking is an extension from Your Honour today and in its written submissions on Friday. The issues that arise from that are these. Firstly, why was no request made earlier? So far as I can see, apart from one footnote to the SPO's written submissions to the very first status conference, the issue of expert evidence has not previously been addressed by the prosecution. It must have been apparent that there was going to be a need to seek an extension before Friday. And the second point, Your Honour, is just what is the basis for extending time? What has been done by the prosecution to obtain this expert evidence earlier? We are, after all, dealing with alleged crimes from 20 years ago, in circumstances where the investigation has already been going on for years. Why does the prosecution not have its expert evidence in hand already? In our submission, without a compelling explanation for that, no extension for the expert report should be granted. The second issue, Your Honour, is in relation to the search material. It's correct to say that yesterday the SPO...
Mr. Ellis, sorry, we will deal with this matter in a separate point for the search material, if you don't mind. So we will come back to that specific point of your submissions after this point, if you don't mind.
Thank you, Your Honour.
Do you have anything else to add to the SPO submissions, Mr. Ellis?
No, not on that, Your Honour. Thank you.
Thank you. And we will go back to this point in a couple of minutes. Let me turn to the Specialist Prosecutor's Office. If you could reply to the different defense teams. Madam Prosecutor.
Thank you, Your Honour. These submissions are largely divorced from the reality of the pretrial disclosure process that has so far taken place. The volume of material which the defence have already received and are receiving this week is more than enough to keep them occupied for the foreseeable future in reviewing that material. The suggestion that there has been any delay in providing such material is not based on reality. What the prosecution has been working towards is the disclosure deadline established by Your Honour, and which we are substantially meeting this week. The timing of disclosure packages and the review of material, the sequencing in which material is being released, is obviously related to the necessity of prioritizing materials for which protective measures are necessary, as those do require advanced applications and additional processing and preparatory steps. Therefore, the SPO worked towards the interim deadlines for protective measures applications and processed material in accordance with that schedule. That did mean that certain other materials for which redactions and protective measures were not envisaged had to wait until those materials were processed in order to meet the schedule outlined. The 8th protective measures request, which was filed at the start of July, was after the schedule that Your Honour had outlined for the filing of protective measures. However, it was not our understanding that that was an exhaustive schedule and that requests for protective measures could only be made on the dates specified. It nonetheless was made at the earliest possible opportunity on which it could be made. The one single factor which has had the most significant impact on the timing of disclosure in this case is not based on prosecution requests or on prosecution processes. It's the requirement for additional subcategorization of materials as requested by the defence. As Your Honour recognised in the categorization decision, requiring that did necessitate an alteration in the disclosure timeline for Rule 102(1)B materials, and we've previously, and as we have previously submitted provision of the Rule 102(3) notice as well as the Rule 95(4) materials are both substantially dependent on completion of Rule 102(B) disclosure. with respect to, I mean, some of the other matters, I think I will actually respond to Defence Counsel indicated they were going to elaborate upon them later in the hearing, and I can respond to them in that context. Thank you.
Thank you, Madam Prosecutor. I think one of the issue today is how do we interpret the word substantially for the Rule 1021B material, and how do we interpret the word exhaustive in my schedule for the different requests for protective measures. Let me go back to the defense. Would any of the defense team want to add anything at this stage on this general topic of disclosure? Mr. Misitic.
Sorry, Your Honor, just very briefly, I would just respond respectfully that the defense is not looking for disclosure of materials to, quote, keep us occupied. We're looking for materials that we will then categorize once we get the whole world of evidence. We will categorize as to what we need to prioritize in our investigations. We're not looking for busy work. And yes, there have been large volumes of material that have been disclosed. As you can appreciate, much of that material may not be relevant to all of the defendants collectively, may be more relevant for one defendant than the other, but just the disclosure of paper doesn't really assist the defense when we haven't gotten the whole world of information. And as we've pointed out in our written submissions, at this stage, there are 102 out of approximately 200 witnesses for whom we have no information about, which of course greatly inhibits our ability to conduct investigations, and I'll deal with that point later. The other point I would mention, just in response on the protective measures application that was filed earlier this month, we have heard a submission now that it was filed at the earliest possible opportunity. Obviously, the defense is not in a position to test that, and we leave it to Your Honor to assess whether that application was filed at the earliest possible opportunity or could have been filed before your 4 June deadline. Thank you.
Thank you, Mr. Misitic. I think Mr. Young and Mr. Ellis requested the floor. Mr. Young, please.
Yes, Counsel, Your Honour, thank you. Counsel, Mr. Thaci, you've just made the busy point that I was going to respond on, so I won't repeat it. Thank you.
Thank you, Mr. Young. Mr. Ellis, please.
Very briefly, Your Honour, I'm still not hearing a clear response on why expert evidence could not have been addressed or obtained earlier. Thank you, Your Honour.
Thank you, Mr. Ellis. Let me get back to the prosecution on this specific topic of the expert report.
Yes, Your Honour, I'm happy to address that. The SPO made early efforts to identify and instruct experts. However, there were certain difficulties encountered in relation to that which required changes. In particular, for example, one of the experts who we had intended to instruct was refused clearance to testify in these proceedings, which required identifying an alternative expert who would be in a position to speak to the relevant matters. And as I have mentioned, all of the underlying forensic material on which those reports will be based is being disclosed by the deadline this week. So we're essentially referring to 3 items, 3 expert reports that are outstanding. Similarly, with respect to all other outstanding matters, whether that be the variation requests or the clearance requests, which relates to 5 individuals, these are extremely limited, extremely discrete requests in light of the overall volume of the case and the volume of material which is being disclosed to the defence teams and is available for their review. Thank you.
Thank you, Madam Prosecutor. You mentioned earlier that 27 August would be the day where you could we could be done with the disclosure of all 1021B material. Is it correct? Have I understood you correctly? And if not, what would still be missing at this date, or what are you not sure to be able to disclose at this date, because it doesn't only depend on your work?
No, Your Honour. The 27th of August date was the date that we are requesting to make the application for protective measures in light of Your Honour's ruling in the decision on the 7th request for protective measures. The other Rule 1021B materials, which I mentioned, is a very discrete, limited number of materials, is subject to the variation and clearance requests, and I'm not in a position to give a firm deadline as to when we will have those rulings or have those clearances. However, as soon as the material does come through, we will obviously be disclosing it promptly. And our request, as made in the written submissions, is that the expert reports would be submitted together with the Rule 95.4 materials. We would, however, have hope that the other materials would have been disclosed in advance of that timeline, including the clearance and variation requests.
Do you see any possibility that the expert report could be disclosed earlier? I mean, earlier than the Rule 95 material. By this, I mean in the months of September, for example, or is this too early according to your current schedule?
Your Honour, I would not be in a position to commit to that at the moment without going into the specific circumstances of the experts. Some of them are do have availability issues with regard to the extent to which they can work on the materials. I would not be able to commit to an earlier date at this time, no.
Thank you. And last question, just to confirm that for the Rule 1023 list, you don't request any change of the deadline, which is currently 30 July. You are on track to meet this deadline, correct?
Yes, Your Honour, that's correct.
Thank you, Madam Prosecutor. I turn to the defense team.
No.
Mr. Mišić.
Very briefly, Your Honor, we remain concerned about the expert witness disclosure. I repeat what I said at the outset, that we were supposed to be ready for trial in July. It is not sufficient to say that the underlying material is disclosed to the defense, and I'll give you a hypothetical since we don't know who the experts are, but I can perhaps make a hypothetical that suggests what they might be. You might disclose all of the pathology reports, let's say, or autopsy reports. The defense is not going to review all of those reports until we see what the prosecution's case is going to be with respect to each particular victim. So it does little to put the burden on us to just start de novo reviewing all of that material. We need to see what the allegation will be with respect to each one of those reports before we can prepare a response. I would also note at this point that the defense, if to the extent there will be experts, will likely want to engage their own experts to both first assist us in interpreting that expert testimony and being ready for cross-examination, and perhaps to have them be testifying witnesses themselves, and that could affect our preparation for being ready for trial at the outset. So, thank you, Your Honor.
Thank you, Mr. Mišić. I don't see any other... No, Mr. Ellis, please.
Thank you, Your Honour. Very briefly, we're 2 days away from the date when the prosecution was supposed to be disclosing expert reports if they were relying on them. And the explanation that's given today for needing to seek an extension is that early attempts were made to identify experts without telling Your Honour when those attempts were made or when the new experts were instructed. It's apparent from what's been said, they're still working on the reports now. And we're, 2 days from the date when the prosecution was meant to disclose this material? In our submission, there has clearly been delay here. And with the accused sitting in detention, no extension should be granted unless there's a better explanation than the one that Your Honour has heard so far.
Thank you, Mr. Ellis. Madam Prosecutor.
Your Honour, only to remind all counsel here of the stage of proceedings that we are at. We are clearly at an advanced stage of the pre-trial proceedings, and the prosecution has met its burden in order to advance us to this stage. However, we are not at a stage where any trial date has been set, and the suggestion that reports or other very discrete items coming slightly after the 23rd of July deadline, and in light of the volume of material which is disclosed and is available, causes any prejudice whatsoever to the defence is misleading. It's simply not accurate in light of where we are procedurally. The steps that are still required to be taken before this case can even be transferred to a trial panel. For example, full resolution of preliminary motions before the appeals panel as relevant. And the suggestion that the very discrete number of identified materials which may be later than the July deadline in any way impacts or prejudices the defence is simply not accurate in the context of the proceedings in this case and where we are at. Thank you.
Thank you, Madam Prosecutor. I indicate the parties that I intend to issue an oral order at the end of this hearing related to the disclosure deadlines. Now let me move to another issue that the defense from Mr. Krasniqi raised in their submissions. This is the issue that Mr. Ellis touched upon a couple of minutes ago, namely the disclosure of material seized during search and seizures conducted in November 2020. I would first like to hear from the defense for Mr. Krasniqi on its request for such material, in particular, its request that disclosure of exculpatory material from the searches to be made within 7 days. Mr. Ellis.
Your Honour, we yesterday received a disclosure package containing a number of documents said to come from the search of Mr. Krasniqi's property. We don't know, of course, whether that represents the totality of what is said to be the exculpatory material on that search. There was a further disclosure package, I think, relating to Rule 1021B material said to arise from the same search. Taken together, that would appear to represent only a small fraction of the documents that were said to be found during the search. But until we've seen what is placed, for example, on the Rule 102.3 list, it's perhaps early for us to comment on that. So we have received some exculpatory disclosure. It was received yesterday. We don't know what else is left.
Thank you, Mr. Ellis. Before I give the floor to the prosecution on this, does any of the defense team wants to add anything on this topic? No. Then, Madam Prosecutor.
Yes, Your Honour, 2 disclosure packages relating to seized materials have been released. One of those is Disclosure Package 44, which was released under Rule 1021B, and the other is Disclosure Package 45, released under Rule 103. The Rule 103 disclosure package does contain all of the materials which have so far been identified as potentially exculpatory from the search materials. Thank you.
Thank you, Madam Prosecutor. Mr. Ellis.
Does that mean, Your Honour, that the assessment of whether documents are exculpatory is ongoing, or that it has been conducted and these are, we have everything?
Madam Prosecutor, because I think you mentioned that, if I read exactly what you said in the transcript, that the Rule 103 disclosure package does contain all of the materials which have so far been identified as potentially exculpatory. So can you elaborate on the so far, please?
Yes, Your Honour. The review has been completed and identified materials have been disclosed in that disclosure package. Obviously, our Rule 103 exculpatory obligations are an ongoing obligation, and the identification of what could be potentially exculpatory may develop as the case develops and as the defence lines of defence or investigation become more apparent. So it is an ongoing exercise that we would need to keep under review. However, the review has been completed, and what has been identified as exculpatory from what's known to the prosecution at this time has been disclosed.
Thank you, Madam Prosecutor. And for what has not been identified as exculpatory? I mean, especially, would there be any Rule 1021B material following these searches that haven't been disclosed yet?
Rule 1021B material, disclosure package 44 contains the Rule 1021B material from those searches. There will be approximately 50 additional items from the searches which are going to be included in one of the forthcoming disclosure packages this week. Thank you.
Thank you, Madam Prosecutor. Mr. Ellis, does it answer your question, or do you have further questions to the prosecution on this?
Your Honour, I'm grateful. I think it does answer most of the question. What remains is whether the remaining material will be placed on the Rule 1023 list.
Correct. It's the question that I missed. Madam Prosecutor, what is not 103, what is not 102.1b, will it be in the Rule 1023 notice at the end of next week?
Yes, Your Honour, it will be, and it amounts to approximately 2,300 items. Thank you.
Thank you, Madam Prosecutor. Mr. Ellis?
Thank you, Your Honour. We'll review it when it comes in. Perhaps we can revert at the next status conference if it remains an issue.
Absolutely. Then I invite you to mention in your submissions for the next status conference, in your written submissions in advance, if you want this point to be put at the agenda. That would be helpful.
Thank you, Your Honour. We will.
Thank you, Mr. Ellis. The next issue I would like to discuss is the use of case-specific categories in legal workflow and other issues raised by the defense for Mr. Krasniqi. First, on the matter of linkage to locations, in particular location categories related to Rule 1021A material and the designation of location names with respect to Rule 1021B material. Second, regarding the linkage to witnesses, in particular, the defense for Mr. Krasniqi requests that the SPO amend the titles of documents in legal workflow to include the relevant witness number, or alternatively, for the SPO to produce and disclose a package for each witness containing all statements or interviews, as well as documents and exhibits referred to by the witness in those statements or interviews. And in addition, the defense for Mr. Thaci submits that it has not received all items mentioned in witness statements and interviews. And third, I would like the defense for Mr. Krasniqi to address its request for an updated version of the Rule 86.3b outline. Let me start with Mr. Ellis, because this mainly stems from your submissions. Please, Mr. Ellis.
Your Honour, on all of those issues or purely on the outline issue?
On all of these issues.
I'm grateful, Your Honour. Firstly, in relation to the categorization issue, the situation, as Your Honour knows, is that the prosecution has been applying categorizations to the 102.1b disclosure that appears on workflow. What we had certainly hoped to achieve by that is a situation where if somebody wanted to search for the documents relevant to a particular category, they would simply be able to run that search on that category in workflow and pull up everything. That would be of assistance not only to us, but also to any party conducting research on that basis, including chambers in due course. The current system doesn't achieve that, and we gave the example that at the time of making the submission, some 19 locations didn't have any documents tagged to them at all. I think I now need to update that, and it's now 18 locations with no documents tagged as a result of some of the disclosures in recent days. The solution to this that we see would be for the Rule 102.1a material to be categorized in the same way. I appreciate that involves a time commitment on the part of the prosecution, but in our submission, it's likely to be relatively limited in the light of the work they've already done to prepare the outline, and the time saving for all parties when conducting searches and when making the categorization process useful is such that it would be worth the time commitment in our submission. So that was why we raised that issue. In relation to the updated outline, this relates to a specific issue that we identified when searching workflow for a witness who'd been identified in the outline, only to discover that it wasn't there, and being told then by the SPO that that witness had been withdrawn, and subsequently a filing was reclassified and made available to us confirming that the witness had been withdrawn. If there are other changes out there, we'd like to know about it. And it shouldn't be the case that we only discover these things on carrying out searches on the existing outline. It would have been better had that been communicated to us. If there are no further changes, then of course the outline doesn't need to be updated at this stage, but if there are, it's relevant to our preparations to know that. And finally, Your Honour, the other matters relate really to practical considerations using workflow. It's all too easy to interpret these as the defence being obstructive, but it's really not. And it's an attempt to use or find ways of using the material that we're being given in circumstances where defence teams have previously made the point at various status conferences that materials being provided in a piecemeal fashion. And what we're really seeking is ways to ensure that when documents are disclosed, they're easily linked to the witnesses to whom they relate. And that's why we've made the proposals for complete witness packages. A proposal I think made previously by the defence for Mr. Thaci some status conferences ago. Either we get a list of the witnesses relied upon and with them the various prior statements and documents shown during the interviews, or at the very least, what is disclosed needs to be clearly linked to the witnesses. And so examples of ways in which that is not done at present include where prior statements of protective witnesses don't always include the witness number in the title, which of course means that as soon as you download it from workflow, you've lost the chance of connecting it up with the witness. And then in relation to witnesses whose identity is known, some of those witnesses are described on workflow. So some of those statements are described on workflow by reference to the name of the witness rather than the unique witness number. And that, of course, becomes a problem because a number of witnesses have the same or similar surnames, whereas the witness number is unique. So for searching for them, the witness number is preferable.
Thank you, Mr. Ellis. Before I give the floor to the SPO, is there any other defense want to take the floor?
Your
Yes,
Honor, we
Mr.
just to note that the Thaci defense joins in those submissions. Thank you.
Thank
As
you,
does the
Mr.
Procedural.
Sorry, Mr. Kaufman.
We also join those submissions, Your Honour.
Thank you, Mr. Kaufman. Mr. Young?
Your Honour, we join these submissions, particularly the submission in relation to one package for each witness. That would make life inordinately more simple and is an obvious example of good case management.
Thank you, Mr. Young. Let me turn to the SPO on all these different requests, maybe starting with the categorization of the Rule 102.1a material and then all the other requests. Madam Prosecutor.
With respect to the request for further subcategorization of materials, first, the scope of additional subcategorization required to facilitate review is a matter which Your Honour has previously ruled on. Your Honour made that ruling following a careful weighing of relevant factors, including the very significant resource and time implications involved in subcategorization, which we've previously outlined at length, the multiple other navigational tools which are or will be available to the defence to assist their understanding of disclosed materials, and the ultimately limited utility of such subcategorization. There's certainly no basis for altering that prior ruling. The subcategorizations done pursuant to Rule 109C and Your Honour's order are simply an additional navigational aid. It's one of a number of such tools available to facilitate the defence's review of disclosed materials, including the Rule 86 outline, which Your Honour has previously recognised provides meticulous guidance to the Rule 102.1a materials and is itself divided by location. It's consequently a relatively simple exercise for the defence to identify from it materials relating to a particular site. Indeed, as Mr. Emerson has rightly noted previously, it needs to be emphasised that the subcategorizations are ultimately of limited utility. They are a guide done by the prosecution, upon Your Honour's order, to provide additional assistance to the defence. They're not a substitute for the defence itself carefully reviewing all of the underlying disclosed material, and running searches on legal workflow subcategories does not absolve them from that responsibility. Indeed, the subcategorizations provided are certainly not exhaustive. In doing the subcategorizations, the SPO was aware that although evidentiary items often speak to many aspects of the case, simply tagging items with every issue would render the function not at all useful. And consequently, the subcategorizations have been done in accordance with the primary issues to which an item speaks. Moreover, our experience to date in applying the subcategorizations has confirmed the very resource-intensive and time-consuming nature of the exercise. It has been a primary reason for the reduced frequency of Rule 102.1b disclosures since that requirement was introduced. That frequency was a matter which Defence Counsel referred to earlier in the hearing, and as we mentioned in previous status conferences, the additional subcategorization was a primary cause of that. Indeed, from the disclosure timetable originally established by Your Honour, it has been the requirement for subcategorization based on defence requests, which above all else has resulted in adjustment to that timetable. And this occurred either directly in respect of the Rule 102.1b deadline or as a knock-on effect for other items which are dependent upon prior completion of Rule 102.1b disclosure. Finally, although not mentioned in the submissions now, the Krasniqi defence did raise a query with regard to the locations included in the subcategorizations, and the locations identified by the SPO and provided to the registry for implementation in legal workflow were drawn from the schedules to the indictment. If there are any particular queries, we do invite the Krasniqi defence team to contact us after the hearing and we'll be happy to address them. Turning to the second item, the request for an updated outline, it is indeed the case that there was only one incident removed from the indictment prior to confirmation of charges and the related evidence withdrawn. That is the incident which the Krasniqi defence have identified, and there was no further similar changes which would necessitate any update in the outline. On the searchability of the materials in legal workflow. The Krasniqi defense have noted that witness codes are contained in the description field rather than in the title field, and that impacts searchability. This is an issue which we had also identified ourselves, and in March we made a request for the description field to be added to the search options in legal workflow. As there are a number of legal workflow upgrade requests pending, this was one we had flagged as a priority matter, and therefore we understand it is something that is already being worked on, or at least is on the to-do list, and will hopefully be addressed shortly. However, in the interim, there is a workaround which we have identified and are using ourselves, and that is to export a CSV, which is basically an Excel sheet, from legal workflow, and from there you can search the description fields for the witness code or, as applicable, witness name, although in principle it is the witness code that we are including in the description fields. If the defence teams have any difficulty in generating the necessary CSVs, I'm sure that the IT Services Unit and CMU would be happy to provide assistance. Thank you.
Thank you, Madam Prosecutor. Mr. Ellis, please.
Well, Your Honour, we stand by the submissions that we've made already regarding the categorisation. Of course, it would take time, but we believe that time would be beneficial to everyone. Regarding the upgrades to workflow, we of course look forward to those if they arrive. It's not only the prosecution that have had difficulties in using workflow over the past few days. There appear to have been problems, perhaps caused by the volume of material being disclosed in the last few days. But we'll have to assess those when they come in. For the time being, the issues we've identified remain.
Thank you, Mr. Ellis. Does any other defense want to take the floor on this? No. On these matters, I think some inter partes discussion could be useful, as suggested by the prosecution. Mr. Ellis, if you agree, you could be in touch with the prosecution, notably for the improvement in legal workflow and for the generation of documents on legal workflow. And I invite both the prosecution and yourself ahead of the next status conference to update me on the remaining issues. Of course, for the question of the Rule 1021A material, this is something that I will have to rule on, but I will do so in the next or for the next status conference after I have an update on these inter partes discussions. I see that it is 20 to 4, so we will continue with the next and last topic on disclosure, and after we might have a break. Let me now move to the request for a preliminary witness list. The next issue we're going to discuss now is this issue that has been presented by the Thaci defense team in its preliminary, in its submissions ahead of the status conference. Mr. Thaci's defense requests that a preliminary witness list be prepared by the SPO with accompanying summaries of the anticipated testimonies. I also note that the defense for Mr. Thaci proposed 2 dates for the provision of such list. I will give you the floor to present this request. Mr. Mishedic.
Thank you, Your Honor. As you indicated, our request relates to our desire to get confirmation from the prosecution as to which of the witnesses that it has disclosed so far it is certain to call a trial, and which it is either not going to call a trial or not likely to call a trial. What we have, obviously, where we have witnesses for whom the SPO has directly obtained a witness statement, we anticipate them being a witness in the case. There are, however, situations where we have received transcript testimony from proceedings outside of this institution. We've received statements that are not directly taken by this institution, et cetera, and it is not clear to us whether those are witnesses that the prosecution intends to call to testify, to submit as evidence, but not as testifying evidence. Some of the way that these materials have been disclosed to us have been categorized as 102.1a material, 102.1b material, and we're not certain at this point, as I said, which of these witnesses are intended to be called as testifying witnesses, even if they do not have a SPO witness statement given to them. So our effort here is to try to prioritize our preparation in terms of which witnesses will be testifying in the trial, and therefore we've proposed that the prosecution prepare a list to that effect. If I just have one moment, Your Honor. Sorry, and we've asked if a preliminary witness list could be disclosed by the 2nd of August, identifying the witnesses that are, again, certain to testify, and the second category would be the witnesses that are certain not to testify. That would obviously assist the defense. Thank you.
Thank you, Mr. Micetic. Does any other defense team wants to take the floor on this issue? Mr. Young, please.
Yes, thank you, Your Honour. Very briefly, just to support this, and with respect, this is a very sensible, good case management suggestion by Mr. Thaci's defence team. And Your Honour may, I don't know if Your Honour has ever worked on a defence team, but until the defence are aware of exactly what the position is or precisely what the prosecution intend to do in a given set of proceedings in a trial situation, where there are potentially hundreds and hundreds of different possible witnesses, one can waste an inordinate amount of time researching, analysing, preparing witnesses whom the prosecution may have already decided they have no intention whatsoever either to call or no intention not to call. So with great respect and very simply, we support this entirely.
Thank you, Mr. Young. I don't see... Mr. Ellis. Oh, Mr. Emerson, please.
I would simply say that we would endorse the application on behalf of the Thaci defence.
Thank you, Mr. Emerson. Mr. Ellis, please.
Yes, Your Honour, we join as well. This is, of course, a matter that's been raised in previous status conferences, and it would still be of significant assistance to the defence in preparing this case.
Thank you, Mr. Ellis. Let me turn to the prosecution. Madam Prosecutor.
Thank you, Your Honour. The concept of a preliminary witness list is one which the defence appears to have borrowed from the Yekatom case at the ICC. The decisions in that case expressly recognised that requiring such a list was an exceptional measure and not something which is generally required. It's certainly not something which is required in the framework applicable to the specialist chambers, and therefore the defence characterisation in their filing of there having been a failure to provide such a list is misleading. A preliminary witness list was ordered in the Yekatom case for reasons which were very particular to that case, and none of which are relevant here. In particular, it occurred in May 2020, near the outset of the COVID pandemic, when strict COVID restrictions were in place and people had relatively recently moved to remote working arrangements. As a result of those exceptional circumstances, the trial panel in the Yekatom case had been unable to schedule a first status conference with the parties, and that is clearly not the case in these proceedings. It also occurred in circumstances where the scope of the charges in Yekatom had been significantly narrowed in the confirmation decision, and therefore there was actually a genuine question as to the extent to which witnesses relied upon for confirmation remained relevant to the proceedings. That is, again, not a circumstance relevant to these proceedings. And perhaps most significantly, it occurred at a point in time 5 months in advance of when it was anticipated that the defence in Yekatom would receive disclosure of the material the prosecution intended to rely upon at trial. It was, therefore, as recognised in the decision itself, simply an interim measure. In this case, the defence already has, or will during the remainder of this week, be receiving the underlying material that the prosecution intends to rely upon at trial. There is no need for interim measures. The information is already available, and the SPO has or is disclosing the material of the witnesses whose evidence it intends to rely upon at trial. The reference to hundreds of possible witnesses is simply not applicable in this case. We have disclosed the material of witnesses upon whom it is our current intention to rely upon their evidence at trial. So in summary, this request appears to have been pulled entirely out of context and without regard to the particularities of the case in which it was ordered, and without regard to the significantly different and more advanced stage of proceedings in this case. Thank you.
Thank you, Madam Prosecutor. Mr. Micevic, do you want to respond?
Yes, thank you, Your Honor. I take the prosecution's position under advisement, but yet I don't see any rationale for why this was so hard for the prosecution to do. They've spent their entire time trying to distinguish an ICC case instead of just explaining why it's difficult for them to put a list of who they intend to call as a witness at trial. It would not seem to be a resource-intensive effort to put such a list together. We do not ask that they be bound by the list and therefore could never change it or add to it or not or take names off of it if they were to choose to at a later date. But it would certainly be a good guide for the defense as to where we should be focusing our case. And as I indicated before, I concede that they have disclosed much material, but that material in and of itself doesn't show us which of these witnesses is actually intended to be a testifying witness and which of these non-SPO witness statements is intended to be submitted as a documentary evidence rather than as testifying evidence in these proceedings. So unless there is a good reason why such a list can't be disclosed at this stage, we continue to reiterate our request. Thank you.
Thank you, Mr. Micevic. Madam Prosecutor, do you want to add anything on the merits of the request?
Only very briefly, Your Honour. The material is with the defence. As I indicated, these are not a list of possible witnesses. These are witnesses upon whose evidence we intend to rely. As to whether they will testify in person viva voce before the court or their evidence will be submitted through some other means, that would be premature at this stage. We're not in a position to make that assessment. Thank you.
Thank you, Madam Prosecutor. Mr. Kaufman, please.
Yes, if I may add a bit of legal justification, I would refer Your Honour to Rule 98, which talks about the transmission of the case file to the trial panel. And as Your Honour is well aware, he will in due course have to provide a handover document. And if I may just refer to Rule 98 1E, subsection V5, that talks about suggestions as to the number and relevance of the witnesses to be called. I would have thought that that would give sufficient statutory basis for the requests which have been presented by the Krasniqi and Thaci team.
Thank you, Mr. Kaufman. Madam Prosecutor, briefly, please.
Yes, Your Honour. Just in reply, I would like to refer the defence to Rule 95.4, and they will see there that upon provision of the witness list, indications as to mode of testimony would be provided at that time. Thank you.
Thank you, Madam Prosecutor. I don't see any party requesting the floor. A decision on this matter will be issued in due course. I see that it is 3:55. If the interpreters allow me, we can continue for a couple of minutes on the next topic of the agenda. Is it possible?
Yes, sir, Your Honor, we're good to go. Yeah.
Thank you to the interpreters. Let us now move to the issue of translation of filings and evidentiary material. I would first like to hear from the registrar on the progress made with regard to the translation of these items, notably whether the language service unit has made progress on the translation of prioritized documents, and whether the parties have made any further urgent requests for translation. I note in this regard that the registry has completed translation of the confidential redacted version of the Rule 86.3b outline, the strictly confidential and confidential redacted version of the confirmation decision, and documents submitted for priority translation by the Krasniki defense team. The only remaining priority translation is the public redacted version of the confirmation decision. I also note that the defense of Mr. Krasnici's concerns regarding a potential backlog of other untranslated filings and future translation of preliminary motions decisions. I would then like to hear from the parties about any difficulties regarding translations, but before I'll give the floor to the registry, Madam or Mr. Registrar. Mr. Registrar.
Thank you very much, Your Honor. I think that you've made the point of what has been made available as noted in our submissions of 16th of July, paragraph 2 and 4. I would only highlight from those submissions, Your Honor, that all of the documents that by law must be translated in a language the accused understands have now been provided in Albanian. All of them, indeed, as of 16th of July, as just mentioned. There's only one document that remains pending due to additional priorities in all of the cases before the specialist chambers since March 2021. And that is the public redacted version of the decision confirming the indictment. Our language services unit is doing its absolute utmost, Your Honor, to provide this additional document by the end of this month. I would, however, also like to stress, Your Honor, that this document has been available already in the Albanian language since 16th of July, however, in its confidential and strictly confidential versions, respectively. This brings me back to the point that all documents, from our perspective, those required under the law, including as per your framework decision of 23rd of November 2020, have been provided. If I may, Your Honor, there were some additional points raised by counsel for Mr. Krasnici at paragraph 13 of their submissions of 16th of July. And that was a reference to their intention to request that the translation in the Albanian language of certain decisions of the pretrial judges, those on preliminary motions, scheduled to be delivered shortly, be prioritized. Consistent with our internal rules on translation requests and prioritizing of translations, Your Honor, we are, of course, available to discuss this point as soon as the decisions are rendered. And as you have informed us, as you have confirmed, they will be rendered tomorrow. So we have all taken note of that. Thank you, Mr. Registrar.
Thank you very much. Let me turn to the defense. Doesn't he have the defense team want to take the floor? I think most of the defense team, I see. Mr. Micevic, do you want to take the floor on this?
We do not have any comments. We have no issues regarding translation. Thank you.
Thank you, Mr. Micevic. Mr. Kaufman, please.
Thank you, Your Honor. Yes, with respect to translations, Mr. Vasili has a general observation and a legitimate expectation. As a citizen of Kosovo being tried in a court operating in the Kosovo legal system, albeit for crimes that he never committed, Mr. Vasili insists that he be given each and every document on which the SPO intends to rely on as incriminating evidence in the Albanian language. This is far more important for his purposes than translations of the court decisions, the operative substance of which has been communicated to him by his defense team. Accordingly, we note that the SPO, according to paragraph 4D of filing 398, is continuing to provide translations of Rule 102.1b materials as soon as they're available. We expect the translations of all Rule 102.1b materials to be supplied to us well in advance of trial, so that Mr. Vasili can constructively participate in the preparation of cross-examination of every witness to be called. For those witness statements subjected to delayed disclosure or redactions to be lifted at a later date, we expect the translations to be made available immediately upon the lifting of the protective measures in question. Thank you, Your Honour.
Thank you, Mr. Kaufman. The translation regime has been set in the framework decision on disclosure. So I recall the parties that if they are in disagreement with what has already been assessed, they must submit a request for reconsideration. If it's a question of prioritizing, this is what we're discussing today. But if any party has an issue with the regime as it is set, then I invite you to make a filing regarding this regime. Let me turn to Mr. Young, please.
Your Honour, yes, certainly there will be a filing in light of what Your Honour's just said. In general terms, we support in its entirety submissions made by Mr. Krasniqi regarding the court's ability to translate documents. With great respect, it's a major concern to the defence, and it's one of the major Achilles heels of the court. No priority requests for translation have been made to date as such on behalf of Mr. Salimi, and that won't be the case until hopefully we will have clarity in relation to Rule 102.1b disclosure as to the relevance of documents and evidence. But I do want to indicate to the court, and this may well have to be in a filing given what Your Honour's just said, that the court should be aware it's likely there will be a substantial increase in requests for priority translations in August and September. So it will be important for the registry to have the necessary resources. Your Honour may remember that over the last few status conferences, I've picked on one or two key case documents and explained what were in our submission the huge delays for such significant documents arriving 6-7 months after the arrests and appearance in court of the accused. Your Honour, I won't go into it in any detail now, but I would support the submissions of Mr. Kaufman on behalf of Mr. Vasili, because we will submit that it's vital. The vast majority of the documents are translated into Albanian, and in either Albanian to English or English into Albanian, and particularly in relation to all the Rule 102.1b material and all the Rule 103 material. And at this stage, I'd like to ask a question, or invite Your Honour to ask the representative from the registry, because I addressed Your Honour on one or two documents to understand the bigger picture of the translation dilemma, as I will call it, and it's a major, major issue. To understand the bigger picture, if the registry have the information to hand, it would be immensely helpful to know, even approximately, what percentages of the disclosed 102.1b and 103 material have been translated either from Albanian into English or English into Albanian, because we strongly suspect there are significant percentages of important materials that simply haven't been translated. Thank you.
Thank you, Mr. Young. Before giving the floor to the registry, let me turn to the Krasniqi defense team. Ms. Lagendra or Mr. Ellis, please.
Your Honour, we join in those submissions and stand by what we've already submitted in writing.
Thank you, Mr. Ellis. Let me give the floor to Mr. Laws also on this issue of translation. Do you have any submissions on this?
Well, thank you. No, I don't.
Thank you, Mr. Laws. Mr. Registrar, on the question of Mr. Young and on any other submissions you can make regarding this issue of translation, please.
Thank you. We would like to thank Councillor Mr. Young for the question. We do not have statistics at hand, but obviously this is an issue that we can look into very soon, and we will report back on it. Thank you.
Thank you, Mr. Registrar. This is noted. Does the SPO has any submissions on this topic? Madam Prosecutor.
No, thank you, Your Honour. We are proceeding in accordance with Your Honour's prior ruling and the relevant provisions of the rules in respect of the languages for disclosure. Thank you.
Thank you, Madam Prosecutor. Does any other defense team wants to take the floor on this issue? No, I don't see any defense team. So we will now take a break for, let's say, 25 minutes approximately. We will resume at 4:30 Hague time. This hearing is adjourned.
All right. All rise. Please be seated.
So let me now turn to the SPO to ask about the status of its ongoing investigations. In particular, whether the SPO can provide further update on the estimated date of completion for outstanding investigative steps, and whether the SPO's estimate of mid-October 2021 to file its pretrial brief and related material pursuant to Rule 95.4 still stands. I also invite the SPO to make any submissions on the procedural calendar in this case. In this regard, I note the submissions of the Victims' Council indicating that participating victims would like to have further clarity on the timescale for proceedings, in particular the anticipated start date for trial and the estimated lengths of trial. While the length of trial cannot be determined at this stage, the start of trial depends on all the issues we are discussing today. I now give the floor to the SPO to provide its submission on the remaining timeline for the pretrial phase, as well as the status of its investigation. Madam Prosecutor.
Thank you, Your Honour. SPO investigations in fulfilment of its mandate are anticipated to continue for the foreseeable future. Such investigations will encompass other cases and other investigations being conducted by the Office, as well as following up on leads in this case. It's the responsibility of the Office, indeed of any prosecution office, to do so, and there is nothing unusual or exceptional about that. And contrary to submissions made in the Thaci defence filing, it has absolutely no impact on Mr. Thaci's right to know the charges against him. Those charges are clearly set out in the confirmed indictment, which delineates the scope of the case. The relevant question is not one of what investigations are being undertaken by the Office, but rather one of what material the SPO intends to rely upon to prove its case at trial. There is a clear legal framework regulating that, and the SPO is fully aware that at a certain point, in the event additional incriminating evidence of relevance to this case is identified in the course of such investigations, it would be a matter for the panel to decide whether or not it may be used. And that decision would be taken in light of the degree of prejudice, if any, which would occur. Such prejudice would primarily arise as a result of the stage of proceedings. As things stand, although the pretrial stage is significantly advanced, the case has not yet been transmitted to a trial panel, and no date for the commencement of trial has been set. So if or when the SPO makes any such application, it would be determined at the relevant time and in light of the relevant circumstances prevailing at that time, including the stage of proceedings. With respect to Rule 95.4 materials, as indicated in our written submissions, there is currently no change in the SPO's estimate. However, there are a number of upcoming work streams which we're not currently in a position to know how resource intensive or otherwise they will be. And that includes possible further litigation on preliminary motions and the extent of defence requests which may be made for Rule 102.3 materials. Both of those variables in particular could impact the estimate. There are also the outstanding variation and clearance requests which have been previously discussed in this hearing and are outside of our direct control, although we would be hopeful, as I mentioned earlier, that they would have been resolved by that time. In relation to the Rule 95 materials, and in particular the witness list, I would like to make one clarification to the submissions that I made just before. the break in the hearing, and that is to clarify that there are a small handful of witnesses whose statements were relied upon in the indictment supporting materials, which the prosecution does no longer intends to rely upon at trial, and consequently we did not disclose further materials relating further prior statements of those witnesses in the Rule 102 1B materials. We'll be happy to identify those witnesses to the defence teams. The remainder of the disclosed material is, as I stated, witnesses upon whose evidence the prosecution intends to rely, and all Rule 102, that goes for all Rule 102 1B materials disclosed. With respect to the queries raised by the Victims' Council and the questions raised on the start date of trial, it is a matter which the parties have previously made fairly fulsome submissions. The SPO's request is obviously for a prompt trial start date 3 months after provision of the Rule 95-4 materials, which is in line with prevailing practice before other institutions trying cases of equivalent scope. In fact, it was precisely that timeline that was established in the Yekatom case, which the Thaci defence relied upon for other purposes in their written submissions. The parties have obviously made differing submissions on this matter, and those are already on the record, in this case, either in written filings or in the record of previous status conferences. Nonetheless, it is, of course, Your Honour who directs the procedural process of the case at the pretrial stage, and the trial panel, which will direct it after transfer of the case. We would therefore consider that the case-specific information available to counsel, together with his knowledge of the framework applicable before this court, both from the law and the rules and from other cases which are proceeding before the court, and his experience, of course, from cases of similar magnitude before other tribunals, would provide a basis for advising his clients. Thank you.
Thank you, Madam Prosecutor. Now let me turn to the defense. Mr. Misic, please.
Thank you, Mr. President. First, let me respond to the issue of ongoing investigations. The defense takes issue with the prosecution's position that it can continue indefinite investigations. Our position is that Rule 4 of the Specialist Chamber's Rules of Procedure and Evidence state that the Criminal Procedure Code of Kosovo must be considered when interpreting the Rules of Procedure and Evidence. According to Article 159 of the Criminal Procedure Code of Kosovo, a criminal investigation must be terminated by operation of law 2.5 years after its initiation. I'm not sure a status conference is the right forum to litigate the issue, but we take the opportunity to put the SPO on notice of our position that we will challenge any additional materials coming in on the basis of both the Rules of Procedure and Evidence of this court and the Criminal Procedure Code of Kosovo. Turning, let me see, to the next point. I note that now the prosecution states that there are no changes to its anticipation of its disclosure of Rule 95-4 materials, but clearly there are a lot of qualifiers that are being attached to that statement, which we interpret as a firm non-commitment to producing those materials on time in October as currently scheduled. We must take note of the fact that our clients are in detention at the moment. We are not in a proceeding where we can take our time and then, depending on how things go, continuously push deadlines further and further along, while the accused in this case continue to suffer the direct harm of being held in detention. So we do think there is an urgency to holding the SPO to the existing deadlines without qualification without opportunity to later come back and say, well, we didn't promise that we would comply with the Rule 95 for obligations by the current October deadline. Finally, with respect to the issue of preparation for trial, we continue to reiterate that there are still many materials that we have not seen, continuing disclosures that still need to be produced. The prosecution continues to not commit to the 95-4 disclosure by October. Expert reports are still being prepared, or perhaps have not even begun to be prepared as we speak. And in those circumstances, we will not be prepared to give an indication of when we'll be ready for trial until we see the SPO's Rule 95-4 materials. Thank you, Your Honor.
Thank you, Mr. Micetic. Mr. Emerson, please, or Mr. Kaufman.
I'd just like to say a word or two before handing over to Mr. Kaufman, if I may. Two things. I haven't intervened, of course, today in the course of these discussions, but it's evident what the thrust of the submissions of the defence have been and what the concerns are, or at very least ought to be, on the part of the court about the way in which the prosecution has been managing its conduct of the proceedings. I should like to say, if I may, on behalf of Mr. Basili, that particularly in the light of Your Honour's latest decision refusing him provisional release, notwithstanding the factors that were brought to your attention, that he feels, and he feels in our submission quite reasonably, that he is being held hostage whilst the prosecution continues to delay the process of bringing the case forward in a timely fashion. So that's the first thing I wanted to say in relation to that. The second thing, and it may be that you'd rather I address this when we come to defence preparation, but in terms of readiness for trial and defence preparation, I should like to seek a clarification from you in relation to the rulings to be delivered tomorrow and in August. But since the question of defence preparation, and therefore implicitly preparedness for trial, is, I believe, a separate item on today's agenda, maybe return to that at that stage. But can I hand over to Mr. Kaufman, please, to deal with any of the specific details that were raised just now?
Yes, very briefly on this matter, Your Honour. It may well be the case that the SPO would like to continue its investigation ad infinitum, but the introduction of any so-called incriminating evidence resulting from such an investigation beyond the disclosure deadline is subject to judicial approval and will be met by a vigorous defence objection. Thank you.
Thank you, Mr. Kaufman. Mr. Young, please.
You have nothing to add, save that we support the submissions made by Mr. Thaci and Mr. Faselli.
Thank you, Mr. Young. Ms. Lagendra, please.
Likewise, Your Honour, we also support the position of the Thaci and Faselli team.
Thank you, Ms. Lagendra. Madam Prosecutor, do you want to reply?
It appears that there is not a significant difference between the parties. What I expressed previously was that we're aware of the framework and that any materials arising from such investigations on which we intend to rely would be subject to judicial authorization at a certain point in time. We acknowledge the right of the defence to litigate that at the relevant time. We obviously do dispute very strongly the Faselli defence suggestion that there has been delay in the process of bringing this case forward in a timely manner. On the contrary, the prosecution has been fulfilling its obligations in an exceptionally expedited fashion and in accordance with the timelines outlined, or has sought or is seeking limited extensions for discrete items of material. Thank you.
Thank you, Madam Prosecutor. Mr. Emerson, please.
That last statement is self-evidently nonsense. The prosecution began this case by suggesting that they would be ready for trial today. The fact that they are now talking about trial, which cannot possibly begin until 2021, makes it evidently clear that they have not, as it was just suggested, kept the timetables they have outlined. So I'm perfectly happy to hear submissions being made that are proportionate, appropriate and truthful, but that isn't one.
Thank you, Mr. Emerson. I don't see any other defense team requesting the floor. Mr. Laws, do you have anything to add on this topic?
Well, thank you. I raised those questions, of course, because they have been raised with me by the participating victims, and I've heard what has been said, and to be frank about it, the questions haven't been answered in any particularly satisfactory way. But I don't say that as a criticism. I appreciate the difficulties in looking ahead in the way that those involved as victims would wish the parties to do. So I'm not going to press the matter today. I hope in turn the parties appreciate the legitimate interest of the victims in having as clear a sense of the future of these proceedings as is possible. And for today, I'm content to leave it there, but it is a matter that will need to be addressed, perhaps at later status conferences.
Thank you, Mr. Laws. Then let us move to the next point on the agenda, which is related to defense investigations. I would be interested to hear the defense on its investigations, in particular, whether based on the SPO's estimates and the ongoing disclosure process, the defense can provide more information on the status of their investigations, whether the defense can provide information on any intention to make requests concerning unique investigative opportunities, and whether the defense can provide information on any intention to give notice of an alibi or grounds for excluding responsibility. In this regard, I note the submissions of the defense for Mr. Thaci and the defense for Mr. Krasniqi that defense investigations are hindered by the ongoing pandemic, the extensive reductions applied to SPO material, and the application of other protective measures such as delayed disclosure. I would like also to hear details about the upcoming presentation of the Registry Witness Protection and Support Office referenced in the submissions provided by the defense for Mr. Thaci. Let me turn to Mr. Micevic, please.
Thank you, Your Honor. You have accurately, obviously, recounted our positions that we submitted in writing at this stage. We don't, at this stage, are not prepared to make submissions on alibi or unique investigative opportunities. We reserve our right to do so after we've received the Rule 95-4 materials. I don't believe we have anything else to add at this stage. Thank you.
Maybe just one point, because you mentioned in your submissions that you expect a presentation of the Registry Witness Protection and Support Office. Is it something that you have liaised with the registry, or is it something that you haven't been able to obtain so far?
I've been advised that, yes, we have been liaising with the registry, and it is scheduled for tomorrow.
Thank you very much.
Thank you.
I see that the matters has been addressed. Mr. Emerson or Mr. Kaufman, please.
Yes, Your Honour. As we mentioned in filing 315 in the case record, the defence for Mr. Vasili cannot commence a substantive and meaningful investigation until it has received full disclosure of the SPO's case, and until all issues of jurisdiction and constitutionality raised in the context of the Rule 97-1 preliminary motions have been decided and avenues of appeal exhausted. The defence for Mr. Vasili cannot be expected to allocate its resources appropriately without knowing where the burden of the so-called incriminating evidence may lie, and without knowing against what mode of liability it is required to defend. Furthermore, the defence should not be expected to provide an alibi until it has been provided with all information detailing how the SPO places Mr. Vasili at the scene of alleged crimes, something which we have quite comprehensively shown to be false in our interim release application. Regarding unique investigative opportunities, we adopt the position advocated by the Thaci defence, and we reserve our position on that matter, and we will introduce a properly motivated request should the need arise. Thank you, Your Honour.
Before Your Honour moves to Mr. Young, I'm sorry, I had my microphone turned off at the outset. Can you hear me?
Absolutely.
Sorry about that. The point I wanted to raise was this. Your Honour indicated at the outset of this hearing that tomorrow the defence and prosecution can expect rulings on the jurisdiction and indictment content challenges, which, as I've understood it from what Your Honour said earlier on, will deal with issues raised by more than one motion. In other words, it's been necessary, for reasons that I think we probably all understand, to group together submissions under certain heads and to deal with them in a ruling. Certain issues could have been raised just as much as jurisdiction challenges or as indictment challenges. But the one thing I did note was that Your Honour went on to say that a further decision on constitutional questions would be forthcoming during the vacation period. And the reason I'm raising this now is because it would be obviously extremely significant if the decision about retrospectivity, the central issue raised in the Vasili challenge about discrimination as between Serbian and Albanian defendants, about the binding or comparably binding nature of the equivalent ruling of the Serbian Constitutional Court, and about the implications of that decision for the continuation of these proceedings and the scope of them, was something which is not the subject of either of the rulings that are due out tomorrow. The reason I say that is because obviously, I mean, it goes without saying that if we're right on that decision, the case against Mr. Vasili is over. There is no other case against him. The prosecution have effectively indicated, they've openly indicated, that there is no evidence against him of perpetration or co-perpetration or aiding and abetting or otherwise participating in any crime at all on the indictment. That's a formal admission that's been made in writing. And if the decision of the Serbian Constitutional Court, which applies to protagonists in the same dispute, in the same conflict in Serbia at the same time, is evenly, fairly and equitably applied to the Albanian participants, that's going to see Mr. Vasili returning to Pristina properly acquitted as an innocent man immediately. The only case that there could possibly be is if there is a maintenance of this candy floss allegation of joint criminal enterprise. So the reason I'm asking is because when your Honour indicated that there'd be two apparently, I mean, potentially decisive rulings tomorrow, and yet a third one not to come until the middle of the vacation, and the third one being one which touches on constitutional matters, since that is obviously an issue which could be raised in the jurisdiction challenge, the indictment challenge, or the constitutional issues, I would like to ask you now to clarify whether the discrimination, in other words, one rule for Serbs, another for Albanians, whether that is in what part of the decision you're going to be ruling on tomorrow.
Mr. Emerson, I'm not going to pre-rule on anything today, and I'm not going to announce what is going to be in the decision. I'm not going to announce what is not going to be in each decision. You will see in my decisions tomorrow. I'm not going to start commenting on a decision that I even haven't signed. So you will see. Would you be
kind enough to indicate what the constitutional decision is about in that case, the one that's not contemplated until August? Would you kindly indicate what that is intended to cover?
The requests that have been made by the different defense team that raise a constitutional challenge. That's it. And you will see in the decision. Now let me turn to Mr. Young, please.
Thank you, Your Honour. Very briefly, frankly, it's very difficult, Your Honour, to provide further information at this stage. I cannot, with respect, comment on a question of alibi or unique investigative opportunities. As has been noted previously, defence's ability to investigate is, we say, heavily undermined by the reason of the extensive protective measures, the extensive redactions, the absence of a pretrial brief, and the vague, as we see it, nature of the prosecution's case. And to put it finally into some sort of overall context, in relation to Mr. Salimi, Your Honour, we would say that presently there are only a very, very small number of allegations of personal acts alleged against him, which in the absence of any joint criminal enterprise would not even amount to crimes within this court's jurisdiction. That's all I can say.
Thank you, Mr. Young. Ms. Salagendra, please.
Your Honor, we stand by what we've said at paragraph 14 of our submissions. Nothing to add.
Thank you, Ms. Salagendra. Let me turn to the SPO. Do you have any submissions on this?
Yes, thank you, Your Honour. With respect to truthful and accurate submissions, the statements that Mr. Emerson has just made are clearly not accurate. The SPO has made no such concessions. The charges and modes of liability set out in the indictment are those which stand. The only thing that the SPO has indicated is the factual matter that direct perpetration is not one of the charged modes of liability. That is the only indication that the SPO has given, and that is a factual matter which is reflected in the indictment. As the defence is aware, pretrial proceedings are reaching an advanced stage. The disclosure of remaining materials which the SPO intends to rely upon at trial is being substantially completed this week, and it is consequently incumbent upon the defence to ensure that their investigations are similarly advancing. I have already addressed the fallacy of the defence's reference to ongoing SPO investigations as being a matter hindering that. Nothing about it hinders or compromises the defence's current ability to investigate. Similarly, the narrative that there are prejudicial delays or that the prosecution was not trial ready in this case, which certain of the defence teams appear to be attempting to present, is simply not based on the facts or on the reality of a pretrial process. Defence counsel are experienced, and they will be well aware, as reflected in the law and the rules, that one of the primary purposes of a pretrial phase is to facilitate the disclosure process. There are obvious and well-known reasons why disclosure can only be effectuated after confirmation of an indictment, once a panel has been constituted and the accused are before the court. These reasons obviously include knowing the scope of the confirmed charges in order to facilitate identification of relevant material, knowing the redaction regime which will be applied, having a panel before which protective measures applications may be brought, and so on. There is absolutely nothing exceptional about this. Indeed, the only remarkable matter is the speed with which the SPO is accomplishing that task. And it's perhaps useful to remind all of the parties that within 6 weeks of the initial appearance in this case, the defence had been provided with in excess of 1,800 evidentiary items, including statements or testimonies from approximately 130 witnesses, as well as the detailed 600-page outline indicating the relevance of those materials. And that is, of course, in addition to having received the indictment itself and the confirmation decision. Since then, regular disclosures of additional Rule 102B materials have continued to be made up to and including this week. Your Honour established the calendar for disclosure in this case, and the SPO is complying with it or making relevant and discrete applications for limited volumes of material. I've already mentioned this, but the single factor which has had the most significant impact on the timing of disclosure in this case has been the requirement for additional subcategorization of materials as requested by the defence. There have also been references to the impact of protective measures. However, those granted are ones necessitated by objective risks. And I think it is worth mentioning that a significant body of evidence has been or is being disclosed to the defence, either with no redactions at all are only with standard redactions. For example, there are approximately 170 witnesses in this case without any delayed disclosure and whose evidence the defence has already or is in the course of receiving. In addition, the vast majority of documentary and video evidence in this case, other than witness-specific items, are being disclosed without any redactions, and that is again a significant volume of material, approximately 8,000 items, excluding prior statements and associated exhibits, that is now or will shortly be available to the defence. So the suggestion that they are hindered or prevented from investigating for reasons associated with disclosure or protective measures is simply not supported. Thank you.
Thank you, Madam Prosecutor. Does any defense team want to take the floor? No. Oh, Mr. Micevic.
Thank you, Your Honor. I must briefly respond. It seems that we're living in parallel universes in terms of what the defense faces and what the prosecution thinks is both how they're performing and what the defense is capable of at this stage. I can only reiterate that we're in a position where 102 out of 200 witnesses we will not know the identity of until at the earliest 30 days before trial. I'm not sure whether some in the prosecution have worked on the defense side and how it is to prepare for trial, but certainly knowing the identity of a witness greatly facilitates how you prepare to cross-examine those witnesses. So we are indeed hindered by certainly first the protective measures regime in this case. Secondly, in terms of disclosures, we still, again, I repeat, have more material to receive, but you're now being told that the prosecution's performance here is, I believe the word used was remarkable, and I can only quote, again, from the transcript of the status conference of the 18th of November 2020, where you were told, quote, "In the SPO's view, there is no reason why this case could not start in the summer of 2021. Now, whether there are objective reasons that cause that problem on the SPO side, I will not get into trying to cast aspersions as to objective difficulties they may have had in meeting that deadline, but certainly to portray this now as somehow the defense painting a different picture, I think distorts what's really transpired in this case thus far. We are not at trial because the prosecution has not disclosed all of the materials and indeed is still qualifying its commitment to provide the 95-4 material in October because they're still not sure they're going to be able to comply with all of those deadlines. In that circumstance, I would say that it's certainly not fair to say to the defense that you're perfectly capable of being ready for trial, even though we're still not even ready to commit to producing our pretrial brief to you. That document, of course, is going to significantly guide how we prepare for trial. And so those would be our submissions at this point. Thank you, Your Honor.
Thank you, Mr. Micevic. I don't see any other requests for the floor, so we'll move to the next item in our agenda, which is the points of agreement on matters of law and fact. I would like the parties to indicate if they anticipate being able to identify a list of issues subject to dispute and one with issues not subject to dispute. In this regard, I note that the defense for Mr. Krasniqi indicated in submission that agreement has been reached on 4 points of fact relating to Mr. Krasniqi's personal background. I also note the defense for Mr. Thaci's submission that it will comment on these matters after the SPO has concluded its investigations and provided the defense with its pretrial brief. Madam Prosecutor, on this topic.
Your Honour, I have nothing to add to that. Certainly the Krasniqi defence has indicated agreement to 4 factual matters relating to biographical data and confirmed that they will keep the remaining proposed facts under review. None of the other defence teams have responded to the prosecution outside of submissions that have been made in the context of status conferences. Thank you.
Thank you, Madam Prosecutor. Does any of the defense team wish to add anything to their previous submissions in previous status conferences or written submissions?
Your Honour, on behalf of Mr. Vasili, we've made our position quite clear from the outset. It's the same as Mr. Thaci's position. We shan't be making any attempt to agree anything until we've seen the prosecution pre-trial brief.
Thank you, Mr. Emerson. Mr. Young, do you want to add anything?
Just to say, I completely support what Mr. Emerson said and what the Thaci team have said. Thank you.
Thank you, Mr. Young. Does Mr. Mitevich or Ms. Alagendra want to add anything to their written submissions on this? No? Thank you. Let us now move to the next topic on our agenda related to detention. I would like the registry to give an update on the measures taken in relation to communication between defense counsel and their clients and the evolution of the detention regime, notably whether the exchange of documents between counsel and the accused in the detention facilities has improved as a result of the updated COVID-19 regulations, and whether the registry will be able or has already resumed family visits of immediate family member in July. I note in this regard that the registry has indicated that improvements have been made to electronic file sharing system, and that in-person meetings between counsel and the accused have resumed. I also invite the parties to indicate if the latest measures implemented by the registry respond to their concern. Mr. Registrar, please.
Thank you, Your Honour. As regards the inquiries from counsel for Mr. Thaci on certain restrictions in the numbers of defence members who can participate in privileged visits to the accused, Your Honour, I would just like to confirm that the practice has been, before the COVID situation, to allow a maximum of 4 defence team members for each privileged visit. The limitation to 4 in-person privileged visitors is, I should add, mainly due to the size of the rooms. Additionally, there is always a possibility to add 1 or more team members via a telephone line. On advice of the medical officer, the limitation for counsel's in-person visits to the accused at this time is 3 instead of 4 privileged visitors. Having consulted with the Chief Detention Officer, we are aware of one request made towards the end of May to add a 3rd defense team member for a privileged visit to Mr. Thaci. The request could not be accommodated at the time, and that, we believe, was only on account of the COVID-19 prevention measures recommended by the medical officer at the time. Again, this was at the time in May. I should also note that back in May, in-person counsel visits were still being conducted with a window separating the participants in 2 separate rooms. That was far from ideal, but it was required because of the situation, the COVID situation. At the same time, remote video visits were also being offered, and they continue to be offered in the present system. So that leads me to the present system. Since this month of July, counsel visits can now take place in the same room with only a plexiglass separating the defense team visitors and the detainee. Here again, the new system has been introduced further to the advice of a medical officer. To give you a concrete idea, the plexiglass contraptions are similar to those in court, this one, for instance. Now, as to the issue of transmission of documents that you mentioned, and I believe that was also mentioned by counsel for Mr. Thaci, I would like to stress that it has always been possible upon counsel in-person visits to the accused to provide a physical copy of documents. However, this was due to the separation in 2 rooms through a detention officer. As of this month of July, the legal teams can now in fact exchange printed documents without having recourse at all to a detention officer, since, as I have indicated, they are now meeting in person with the accused. If I may, we are glad to note in passing that the SEDS system, a file server, has been introduced in March 2021 to allow digital sharing of documents between defense and the detainees, and that it has been welcomed by all, I believe, and used by defense teams with Also here, I believe no particular concerns, although I'm informed that there were some initial issues with access and how to get into, how to make it work. But I think it has been, these inquiries have been resolved. We have, since March, substantially increased the storage capacity available for all defense teams on the system, the said system, and that has gone well also, I believe. Currently, we are looking to add more storage capacity if and when required. Your Honor, you also asked about the family visits, and indeed these were mentioned in the submissions. I am pleased to confirm in this regard that due to the easing of COVID-19 measures, on the advice of the medical officer, in-person family visits have resumed as of 15th of July for immediate family members, as had been anticipated. The registry is actively supporting the logistics implied for those seeking to visit. As of today, I believe that all of the accused in this particular case have benefited from such visits. We will continue to support them and to make them possible, these visits, considering also the evolution of the COVID-19 situation and the advice of our medical officer. Thank you, Your Honor.
Thank you very much, Mr. Wolfhard. Let me now turn to the defense. Does any defense team want to take the floor on this, these issues? And notably, if there is any remaining problem regarding visits. Mr. Young.
Very briefly, as your Honour knows, we are pursuing the release of Mr. Salimi on provisional release terms. But I would like to thank the registry because there is an improved facility for sharing information, and that's been a useful progressive development. I also thank the registry for facilitating the meetings which are in person in the meeting rooms, which does significantly improve the previous position. So that's all I say. Thank you.
Thank you, Mr. Young. Mr. Mitevic.
Thank you, Your Honor. Yes, we confirm our agreement with the registry's submission on the improved conditions. Obviously, there is still the limitation of the number of people that can visit, which can hamper our communication somewhat because we usually bring an interpreter with us. But the conditions indeed have improved, and we're grateful to the registry. Thank you.
Thank you, Mr. Micitic. I don't see any other counsel requesting the floor. So we can move to the next topic. And let me also thank the registry for all the efforts that have been made, both for communication between client and counsel, and also for the family visits. Before I give the floor to the parties on the date of the next status conference, I note that the Krasniki defense, the Salimi defense, and the Veseli defense have lodged an appeal against the decisions of review of detention. I would like to ask these defense teams if they intend to request a postponement of the next review on detention of the accused after the decision of the Court of Appeal is issued, as they requested during the last appeal on detention, or if they prefer me to review the detention 2 months after my last review. And I will turn to the Krasniki defense team because it's the first team that lodged an appeal. Mr. Lagendra.
Your Honor, we would like to request a postponement as we did previously until the appeal is disposed of.
Under the same modalities?
Yes, Your Honor.
Thank you, Mr. Lagendra. Then the second appeal is for Mr. Salimi. Mr. Young, please.
Your Honour, may I briefly just simply request 24 hours to consider our position and revert to you within 24 hours?
Absolutely, this is noted. You can do it through a filing tomorrow then.
Thank you.
Thank you, Mr. Young. And then the defense from Mr. Veseli. Mr. Emerson, please.
Apologies, I was muted for a moment. We do not seek an extension. We request that you continue with your obligation to review detention at the statutory period, please.
Thank you, Mr. Emerson. This is noted. I would now like to ask the parties for their views on a suitable date for the next status conference. I inform the parties that given that trial panel 1 will start the trial of case 5 on September 15th, the courtroom will not be available in the weeks following that date. I therefore suggest that we convene the next status conference on Monday, 13 September, or on Tuesday, 14 September, at 14:30 Hague time, which seems to be the preferred timing to accommodate counsels in their respective time zones. Madam Prosecutor.
The prosecution will be available on either of the proposed dates. Thank you.
Thank you, Madam Prosecutor. Mr. Micetic.
Thank you, Your Honor. The Thaci defense will be available on either date. Thank you.
Thank you, Mr. Micetic. Mr. Emerson, please.
No difficulty, Your Honor.
Thank you, Mr. Emerson. Mr. Young.
Either date works. Thank you.
Thank you, Mr. Young. Mr. Lagendra. Microphone, please.
The same, Your Honor.
Thank you, Mr. Lagendra. Mr. Laws, please.
Well, sorry to say I do have a difficulty with those dates. I have a professional commitment in the United Kingdom, which I simply can't change. But I'm very conscious of what John said about a trial starting on the 15th. So I'm not going to suggest that it's delayed beyond the 14th, and I will simply do my best to accommodate the court.
Thank you, Mr. Laws. This is much appreciated. And I suppose the registry doesn't have any problem with one of these dates. Thank you very much. As usual, I invite the parties to make written submissions if they would like to raise any specific issues during this status conference, and you will receive a scaling order in due course that will include the agenda. At this point, I would like to ask the parties whether they have any other issues they would like to raise. And as usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information. Madam Prosecutor.
No, thank you, Your Honor.
Thank you, Madam Prosecutor. Mr. Micetic.
Nothing from us, Your Honor. Thank you.
Thank you, Mr. Micetic. Mr. Emerson, please.
Nothing, Your Honor.
Thank you, Mr. Emerson. Mr. Young, please.
No, thank you.
Thank you, Mr. Young. Mr. Lagendra, please.
Nothing, Your Honor. Thank you.
Thank you, Mr. Lagendra. Mr. Laws, please.
No, thank you, Your Honor.
Thank you, Mr. Laws. Before we end this hearing, I will issue 2 oral orders. I will issue my first oral order concerning the SPO's deadline for Rule 1021B material. In light of the outstanding redaction requests, pending clearance requests, and delays in relation to expert reports, I hereby vary the deadline for Rule 1021B material disclosure to 27 September 2021. And I will issue my second oral order on the timeline for the next review of detention regarding Mr. Krasniqi. After having heard from the parties, I hereby order the defense for Mr. Krasniqi to provide submissions on whether reasons for continued detention still exist 10 days after notification of a decision by the Court of Appeals panel on pending appeals against the pretrial judge decision denying interim release. Response and replies shall follow the timeline set out in Rule 76 of the rules. And should the defense decide not to file any submission by the aforementioned time limit, the SPO shall file submission on the next review of detention 10 days after the defense deadline. Response and replies shall follow the timeline set out in Rule 76 of the rules. And this concludes my second oral order. This concludes today's public hearing. I thank the parties and participants for their attendance, and as usual, I thank the interpreters, stenographer, audiovisual technician, and security personnel for their attendance. The hearing is adjourned. Thank you.
All right.